Good evening. This is Rahul Reddy live here from Houston, Texas. Every Tuesday from 5 to 6, we take live questions and live show from Houston, Texas. Emily, what do you have today to discuss?
Yeah, we want to talk about why is it that legal immigration and reform for legal immigration is just never talked about in the media, and why do we never hear about it? We also want to talk about employment-based green cards still being approved after September 6th, even though we know that green cards are used up by that point. We get a lot of questions about the H-1B lottery, and when someone's had an H-1B in the past, at what point do they have to go through the lottery again? Is it within 6 years if they don't use that time, or is it 3 years, or is there any limit at all? What are the things that need to happen in order to have to not go through the lottery again? And the Child Status Protection Act, aging out kids. What do you need to know about it? Is your child at risk of aging out? How do you know? And at what point is their age locked in so where you don't have to worry about it anymore?
One of the reasons why I think so media, the Congress, they don't pay for the legal attention is only when there is something, everything is good about something, they don't discuss about it. When there is something bad about it, they discuss. And the only thing is that they put all the good things and bad things in one basket. And that's our problem. When we try to address with the Congress and the media, there is kind of business immigration. We never knew that. Mm-hmm. When we meet with the congressmen, they're like, I thought only people jump the walls. Not congressmen, but most of the people jump the walls and comes into the United States. They don't understand about business immigration. In fact, business immigration is only 14% of the entire immigration. Approximately 1 million green cards are given every year. Only 14% comes from the employment-based immigration. The rest of family immigration, and of course there is called political asylum, suspension of deportation, lottery system, many different methods of green cards are available, but when it comes to the employment, it's only 14%. That's the reason why also the attention is not paid. The undocumented aliens who are in United States, they make a big noise. I mean, they're really suffering, obviously. I'm sympathetic to them. I'm sympathetic more to the employment-based. It's not that I tell the other people are not bad people, but they're suffering much more than the employment-based. At least that's what they feel. And they make a lot of noise. And the employment-based immigration people, I mean, these people are, especially most of our clients, their family income is more than $100,000 a year. They live in luxury house. So they don't feel the pain, and they don't feel that they should voice it. Maybe they fall in love with us, and maybe they like us. They like immigration lawyers, which they should not. They should not like immigration lawyers. They should try to get the green card. And that's the reason why I feel that it's not been heard. And there are many non-profit organizations, especially a lot of non-profit organizations, YMCA and certain other organizations. They support more undocumented aliens immigration. They support more what is that employment authorization they give it when there is a hurricane, storm, or something like that. What is it called? Temporary Protection Act. Yes. And they support more of those things. There are organizations, for example, AILA, American Immigration Lawyers Association, which is a combination of both business immigration lawyers and also the other immigration lawyers. But business immigration lawyers are a minority there. If you look into their lobbying efforts, they do much more lobby efforts when it comes to the other immigration. When it comes to the employment-based immigration, they don't. And also historically, it's always been the people who have been persecuted outside, the people who wants to come here based on the relative basis. They came into immigration and they formed these, they are the main foundations of this country. They didn't come on an employment-based visa. Back in old days, there was none at those point of time. And so this employment base is relatively new compared to the old one. That's another reason I feel that, hey, this needs to be paid attention to. In fact, some older generation immigrants here who actually got benefited through the employment-based also, they don't support employment-based immigration. I was very surprised though. And one of the reasons is that they think an employment-based immigration is easy. Back in olden days, Emily, the employer has to take the employee to the USCIS office. He is my employee, give him the green card. That's it, they used to give the green card in those days. Of course, by the time when I came, it was the same labor certification, employment process and all those things, but still, we were getting into adjustment of status within 1 year. And then the next batch comes in all the way until about 2007. The batch was so easy to get the green card. Now, all of a sudden, people are suffering, but still the older immigrants who are from who got benefited don't care much about them. Look at it. We have the vice president of this country, who is a second generation immigrant. We have the top CEOs of the company. I mean, what top CEOs of the company? Microsoft. We have Microsoft CEO Satya Nadella. We have Google CEO Sundar Pichai. These people are also benefactors of the employment-based immigration. But then at that point of time, their immigration was quite different than the immigration right now. So they tend to forget it. They tend to not support their fellow beings who are climbing up of the ladder. Anything else, Emily, that you feel?
No, I think that covers it perfectly.
And also this religious organization, Emily, that I feel they still tend to support the undocumented aliens much more than the legal immigrants. Probably they feel more sympathetic to those people than that of the legal immigrants. That could be the reason, what I can think about. But what I suggest right now to the people who are listening today, we know the sufferings of you guys because we do the H-1B extensions, we do the EAD extensions, we file the adjustment of status. You have to wait for decades to get the green card application. But we want you to voice a little bit to the Congress, if not more, because I know your sufferings. Whenever you get the H-4 extension, it doesn't come in time. Whenever you go to India, whenever you go to home country, you have to get the H-1B, H-4 stamping. And things are very tough. We want you to, at this point of time, write a letter to the congressman, to the USCIS, of not counting the family members, though, because that's the easiest apple the administration can do. If we were to request the Congress to pass a legislation, they are not doing it. We've been trying that so many efforts. We tried the efforts of getting all 280,000 green cards. Man, oh man, they give it. Entire 280,000 green cards have been given. We want you to do your efforts to write the letters that if don't count family members in the employment based. We have 140,000 green cards. The law is not clear on it whether they should count the family members or not. The administration can choose not to count the family members. And if they choose not to count the family members, it automatically goes to 300,000 immigrant green cards every year. That's a good number. We can live it. Even with the 7% limit, though, if they take this not counting family members, we're going to go to 300,000. Now, when we want to remove the 7% discriminatory thing that is there imposed on some nations, for example, India and China happens to the one who is suffering, it requires Congress, that is a parliament, to pass it. But for this, not counting the family members, we can get it done by the administration. So we want you to do this little efforts. Wherever community organization you go, we want you to voice it. Put a non-profit booth. Hey, we are students. We're coming here, or we are people who are suffering from the immigration in the ethnic organizations. Go and put a booth. I mean, if you want some contribution from me, yeah, I'm willing to. And you guys are good enough for the financial. How much it costs for you to put a booth and volunteer, and have each and every person coming into the organization sign a document saying that I support non-discriminatory immigration. We support not counting the family immigration. Let them write a letter. Take some laptops. Let them write it there itself. Because if you tell them to do it later on, you know what they're going to do? They're going to forget it. They're not going to do that. We know that. I'm in that circle, believe me, guys. I'm a little bit older than most of you guys, for sure. And in my circle, they have no clue what you guys are going through. They only think that the immigration is only there for 3 years after that they get the green card. So please keep educating the older immigrants who got the green card through the employment based, and keep voicing with the Congress and with the administration.
Yeah, and another thing, I think one area that you could focus on is the issue of kids aging out, the legal dreamers. I feel like they get a lot more traction when it comes to Congress in terms of possible reform, because they're kind of in a situation where they've done everything right and they've lived here all their lives, but there's nothing for them if they happen to age out because this process is taking so long. And again, it's the other people that went through this process before. They never had to deal with that before. They never had to think about, should I have a kid in the US so they can sponsor me in 21 years? I mean, I filed one of those.
I do.
You know,
They came as an immigrant, they stayed in non-immigrant visa, they couldn't get it, and they eventually got it through.
Yeah. And so with the legal dreamers, I feel like there's a lot of support in Congress for that, to where that may be an area where we can get some reform, possibly during the lame duck session. But to get these other reforms, removing the 7% cap and anything beyond that is very difficult in Congress until you can get 10 senators, Republican senators, on board to beat the filibuster. Beyond that, we need to focus on things that the administration can do that can be done by executive order. And that's where we'll have better chances of making an impact right now.
On the issue of the green cards, do you see still approvals after September 6th, Emily?
Yeah, surprisingly. Now, it's certainly not to the extent that we were getting prior to. We were seeing approvals coming in on Saturdays, Sundays, on Labor Day, Monday. They were even issuing approvals. But after September 5th, they drastically dropped off. Now, of course, we're just now starting to get some of those approvals, but definitely we've seen a couple come in. With the notice date of after September 6th, when supposedly green cards were not available. We don't know if that means that those people already had it allocated before that announcement was made, or who knows.
One thing is, Emily, when we go for the interview of the 485, in fact, there are a couple of interviews that happened in the last 1 week from our office, though. The officers clearly mentioned to us that we cannot approve the green card. In fact, the interview that happened on September 6th, by the time interview happened, the visa numbers went out. So the officers told us, no, we can't grant the green card, even if the prior date was September of 2010, which is current in October of 2010. They said 2022. They said we're going to approve it as of on October 1st. So in the interview, though, we never got any of those approvals, though. What happened is that when we are looking into the dates, maybe we are not looking into the proper dates. When they're putting a notice date, an approval date, and so date, though, I think so that it's just the date that they printed the 797. That's what I am assuming, though. Because if not, then why would they not approve when we go for the 485 interview? That's the main question, though. But for the people who have not yet got the green card, though, I don't want them to keep a lot of hope on it, at least by the September 30th, if you're hoping. I don't want to, but if the thing comes in, you definitely can take it. But not expecting very many more than what already occurred.
All right, next up on H-1B. So a lot of questions come in about, hey, I had an H-1B in the past. Am I considered to be counted in the cap, or do I have to go through the lottery again? And I think there's a lot of misinformation about that out there on the internet. A lot of times I hear people say, well, I got my H-1B approved. It was 4 years ago. It's expired since then. So now I have to go through the lottery again because I never extended it. I never activated that H-1B and came into the US. But technically there's no time limit on that 6 years. So once an employer sponsors you and you get that approval, you get a 6-year window of H-1B time. You can use that 6 years at any time. It doesn't have to be right then and there. So if you were in the US for 1 year and then you left the US, 10 years later, you can recapture those 5 years and come back on H-1B without having to go through the lottery again.
Emily, I have some questions on it. Let's say I have H-1B, I'm here for 4 years. I got my I-140 approval. Now I want to go to India. Can I stay there for 6 years and come back here again?
Yeah, absolutely. You can get.
Do I need to be subject to the cap?
No. So when you're ready to come back, so you used up 4 years, that means you have 2 years left. You stayed out of the US for 5 years, let's say. When you're ready to come back, you need an employer to sponsor you. It does not have to be the same employer that sponsored you before. They'll file an H-1B petition requesting consular processing. Since you're outside the US, you'll be able to get a 2-year approval. And then with your approved I-140, you can actually add on an extra year to get a full 3 years, get that visa stamped, come into the US, and then continue your H-1B status. You would need the new employer to file a new labor certification, new I-140, so that you can eventually get the green card when your priority date is current, but you don't have to go through the lottery
So
again.
Even if the I-140 is not approved, or even if the I-140 is approved, I can still come back if I used only 4 years of the H-1B.
Yes.
Emily, what about the situation where that let's say I used up 6 years of H-1B and my priority date is 2015 February, and I go to India and the final action date becomes current. Can I still come back in H-1B?
You can, but in that situation, once your final action date is current, you're no longer able to get those 3-year H-1B extensions. Now you can only get 1 year. So again, your employer at that time, whether it's the same employer or a new employer, needs to file a petition for consular processing, but it's only going to be given for 1 year. Then you get that visa stamp and come into the US. You need to make sure that you have the new labor and new I-140 in place and get that 485 filed by the time your final action date is current. Otherwise, you may have difficulty getting the next extension. So you have to be careful on that timing.
Emily, I am on H-1B for 2 years. Now I converted to the H-4. Can I come back to H-1B without subject to cap?
Yep, absolutely. Now that you can file a change of status while you stay in the US. You can file it any time of the year. You don't have to worry about the April filing for the October 1st start date. The thing to be aware of is if you are on H-4 or any other status that does not have work authorization, you have to wait until the H-1B change of status gets approved before you can start working. So I usually file that type of application in premium processing so you can start working as soon as possible.
Emily, I got my H-1B approval and I used up 3 years. Now I spent 6 years on H-4. Can I still come back on H-1B without subject to cap?
Yep, absolutely.
Isn't there a limit of 6 years there that my first H-1B must have got 6 years ago?
No, and that is where a lot of confusion comes in because the old form used to ask that question, but they clarified that in the 2017 regulation and confirmed that there is no time limit on you being able to recapture the time left in your 6-year limit.
So when would I be technically counted toward the H-1B number? What if I'm in India and I got the H-1B approval but never got stamping? Does it mean I might counted toward the H-1B?
That one, they could come back and say, no, you have not been counted because you didn't either get the visa stamp or be granted entry into the US in H-1 status.
What if I got the stamping with company A in 2010, but I never entered into the United States on H-1B stamping? Can I still get a H-1B with a different company without subject to cap?
Yes, you can. Once you got that visa stamp, that shows that you've clearly been counted in that old cap.
Anything else, Emily, on this?
Nope, I think we're good on that. Next up is the, this idea of kids aging out. What are the things that you need to be aware of? If you're in that situation, if you have teenage kids now and your priority date is years off, what are the things that will lock in the child's age?
Emily, to lock in the age, that means that even if the children are in adjustment of status, even if they cross 21 years, there are under certain conditions, their age will be locked. In other words, just like angels or some people, they never age. They never cross the 21 years old. I hope we are that. What need to happen for the, what do you call, angel age or whatever it is? They must file a 485 application, that is adjustment of status application. The final action date, not the filing dates, the final action date has to be current. The I-140 must be approved. If the I-140 is pending and you have filed the 485, no. So the I-485 must be filed. The I-485, the final action date has to be current. The I-140 has to be approved. And the CSPA, that means Child Service Protective Age, has to be under 21. What does that mean is that the amount of time period the I-140 is pending will be deducted from the time of the age. If all 4 of the things happen at one time, all 4 has to happen at one time. You can't have happen one at one time, one at one time. If all 4 happens at one time, the child will be locked. So especially for the people whose priority date is 2014, Emily, I'm a bit concerned about some of these people who are filing, because most of these 2014 priority dates, they filed it in October of 2020. Now, they filed in EB3. Later on, they converted into EB2. The problem with them is that they were never locked in EB3. The reason they are never locked in EB3 is the priority date never became, final action date never became current under EB3. Now, when it comes to the EB2 interfiling though, it's not a guaranteed source that they can, just by filing the interfiling from EB3 to EB2, you cannot assure that your EB2 is protected, because USCIS has clearly directed us that it's not a process guaranteed. It's up to the discretion of the officer to approve it or not approving in the EB2. So if they fall into 2014, Emily, though, if they don't want to take any risk, the better way probably would be refile the entire application, because as of today, the official record on the visa bulletin is that the final action date is not current. And you may ask a question, can they file in 10 days? Yeah, absolutely. In fact, there was a labor certification case, Emily, that was approved at 2:43. Before I came to the meeting, we applied for the I-140 and 485. In 3 hours, everything is done. That's good. The client cooperated by sending the passport pictures way before. We made everything ready. But yes, that can be filed. So people want to assure that they want to file the I-485 before to lock their child's age. The other thing I told Emily was that the I-140 application pending time will be deducted from the age. Especially what to do if your priority date is somewhere in December of 2014 or 2015. Sometimes simply, this is what you came up with the creative idea. I didn't got the idea. Is you withdrew the I-140 application of that person. You refile the I-140 application. One reason is that, let's say the I-140 has been approved in 2 weeks. You're only deducting 2 weeks age from the kid. So what Emily did was that she withdrew the I-140, refiled the I-140, and when you refile the I-140, you don't do premium processing. USCIS takes 2 years approximately to approve the 485. So the child will become 21, not when they are 21. If the case I-140 is, they will become 21 when they are 23. That's called Child Service Protection Act. The time period of I-140 will be deducted. So there are some creative ideas where we can prolong the age of the kid, though. And people come to the question, oh, my kid turns 21, he gets kicked out of the H-1B. Can I still file the 485 if he's protected under the CSPA? Yes, even if the kid moves out to an F1 visa, Emily, we can file the 485 even if they come under the CSPA under 21 age.
And the important thing to know there is when you're trying to calculate that CSP age based on how long the I-140 is pending, it's based on the I-140 that forms the basis for your 485. So if you have multiple I-140s, you have to look at which I-140 are you using to file the adjustment of status. Only that one do you look at how long it was pending and then subtract that from the age.
Questions are coming with regards to the transfer of underlying basis. A lot of people are asking the question with regards to, hey, I filed a transfer of underlying basis. Am I in EB2 or EB3? I don't know the answer. We don't know the answer yet. Now, here is what I will do, though. I will consider, because we don't know whether EB3 moves forward or EB2 moves forward. If you have already filed the transfer of underlying basis, though, if the EB2 moves forward, I will request the USCIS, look, my guy has filed a transfer of underlying basis on so-and-so, here is evidence of it, give me the green card, because his date is current in EB2. Now, in case, if the priority date moves to EB3 moves forward, though, I'm going to file a transfer of underlying basis again and request the USCIS, look, this guy is current in EB3, I want this guy's case to be approved in EB3. So I will switch the things, though. Now, there are some people who are asking question, should I file the transfer of underlying basis right now? No, I would not suggest, because the priority date is April 1st of 2012 in EB3, and EB2 is April 1st of 2012. It doesn't matter whether they consider my case in EB2 or EB3. Either way, it's April 1st of 2012. Now, going forward, though, if the final action dates moves to the left or right, then I am going to move based on how they are going to move. So right now, I'm not going to file anybody's transfer of underlying basis. We do not recommend to file underlying basis, but keep watching our YouTube channel. Week by week basis, we may change our opinion. If you keep listening to us, you will be in a better hand. So we will tell you when to do the underlying basis, though.
Sonia is expecting the perm approval to come in soon and has a 2011 priority date and wants to know if she applies for the I-140 with premium and the 485, what will the processing time be? Although we've seen very fast processing time in the recent months, people filing in April, May, June getting the approval by September. Don't expect that to continue. That was a very unique situation where USCIS knew they screwed up the year before, wasting 60,000 green cards, and they didn't want to face that again. So they were making sure they were approving things quickly. Now we don't have as many extra green cards, and they're going to go back to taking their sweet old time. They still have all these October 2020 filings to get through. There ended up being 100,000 filings in October, November 2020. We finally got some data on that. And generally, processing times are not great for the first 2-3 quarters of the fiscal year. I looked back to some of the records today. I'm going to do a blog post about this, but basically every quarter they normally approve about 30,000 I-485 applications. That's only employment based, but all categories, all countries. And so that's normal. I expect them to go back to normal, which means slow processing time.
Yeah, and a lot of people are asking us to predict the priority dates. We have got a lot of criticism also on the predicting the priority date. Okay, that guy is better, this guy is better. Eventually, guys, we are all shooting the dart in the dark. Believe me, there is no certain principle that anybody can predict the priority date. The only one person that can predict in the priority date is the Almighty God. That's all I can tell. And here is some of the reasons, though, when people are telling what's the priority date, there are 200,000 green cards right now available. At least that's what they said to us. So if I look into the data of the employment-based history, in the preceding 10 years, though, okay, in the preceding 10 years, the minimum used by the rest of the world, that means other than Indian nationals, the minimum that they have used up is 106,000 is the minimum that they have used. But in an average, Emily, they have used up approximately, not counting the last 2 years, because we have excess numbers in the last 2 years. So in an average, they used about 115,000 green cards every year. Okay, 115,000 is the rest of the world has used. Now, if they use the same amount of 115,000, though, the Indians should get approximately around 85,000 green cards, though. But if you look into the last 2 years, though, Emily, in the last 2 years, they have used up approximately around 150,000 green cards. To be exact, I think so. It's going to be, yeah, it's 153,000 green cards in the last 2 years, though. So if you average both the things to 115,000 to 150,000, it comes to about 135,000. I'm not a good mathematician. So there are only 65,000 green cards left over for the rest of the world. But if they use it, the 187, like the way they used it this year, then we will have only 13,000 left for the Indians. The way it works is that if no other countries use it, Indians will get more. But if the other countries are using more, then the Indians will get less. Indians are guaranteed to get approximately 7% of the 140,000. In fact, it is 200,000 right now. That's approximately around 14,000 green cards. That's for sure Indians are going to get it. Then the rest of it will be based on how much the other countries are not going to use. Last year, the non-Indians have used 187,000 green cards. So assume they can't use 187 this time. So if they use 186,000, the Indians will only get, if they use 186,000, Indians will only get 14,000. But if they use less, though, then Indians will get more. So if you look into the data, though, approximately 60,000 employment-based EB2 and EB3 are pending for Indian nationals. Unless the other countries don't use, the movement will be very less. Now, how we cannot tell that the other countries won't use it? Here is a problem there. Even if they give us a data saying that the other country nationals, X number of cases are pending, we can't take the data and interpret it, Emily. Because starting from October 1st, the other country nationals will still file. Indian nationals most probably will not file that much because the prior date has not moved starting from October. For other country nationals, it's a routine basis. They have been filing, they have been current all along. So they've been current all along. They're going to keep filing in the same pace. So we don't know about how much the other country nationals will use. So it's very hard to predict it. And you said that they're going to use approximately 35,000 every quarter or so. In general, what I've seen a trend, Emily, in the first 2 quarters, they go a little bit slowly and then they go fast enough. I don't know whether they're going to gauge to see if the other country nationals are not applying, and then they will go forward. I don't know. That seems to be the way that they do it. So only in the third quarter and fourth quarter, we see the other country nationals not using it, then they will try to move the Indian nationals. That's been the trend for most long. And that's the main reason why we can't predict the demand of the other country nationals until we go to the second quarter. And that after second quarter also, we don't have the data. Only the USCIS has the data. They don't release it until about, after 3 months or so, where it becomes very old. So that's the reason why we cannot predict it though. So for those people who have been waiting in the priority date, definitely I would want you to prepare either way, to prepare for the 485, if not wait for a long period of time. And one other thing that I noticed, Emily, is the EB1 green cards though, is that the way they used to approve the EB1 green cards, they have done a little bit of liberalization policy since this administration has come in. And if you look into the EB1 approvals, they have gone significantly higher in the past 3-4 years. And that past 2-3 years, that shows that we may have less spillovers into EB2 and EB3. So please take these statements, and we can't give the numbers, and interpret it your own way, guys.
All right, Ayushi says, I'm on F1 OPT. Can I get a visa stamp anywhere internationally, or does it have to be my home country? So technically, most people can get a visa stamp in any other country as long as you can legally get to that country. However, for F1s and B1s and B2s, for example, these are non-immigrant intent visas. That means that you need to be able to convince the consular officer that you do not have immigrant intent. You do not have the intent to stay long-term in the US, that you're only coming for the purpose of studying, and that you intend to go back to your home country at the end of your F1 studies. That becomes harder to do in a third country. So for that reason, it's generally recommended for someone who's applying for an F1 visa or a B1 or B2 visa to always apply in their home country, where they can show that they have those ties to their home country, to show that they do intend to return back at the end of their F1 studies.
Naveed has this question. What happens to the USCIS promise to adjudicate 485 in 6 months starting 2023, where 2020 applications are still pending? Good question. Yes, we remember the promise. We will remind them the promise. But here is one thing, Naveed, is that if the final action date is not current, we cannot even request the USCIS for the 6 months. The 6 months timing will only come in when the final action date is current. It does not come in when the final action date is not current.
Ravi Teja has a visa stamp that's valid until September 2024, but when he last entered, he got an I-94 that's only valid till March 2023 because his passport's expiring. His employer said they will file an H-1B extension, but it can only be filed 180 days before the expiration. Is that correct? Yes, an H-1B extension can only be filed 180 days before the current one expires. So if you don't want to go through the extension process, assuming that you've got your passport renewed, you can just take another trip outside the US, come back in, and you'll get another I-94 that should be valid till September 2024. In your case, because you have the visa stamp, you can travel anywhere. But for someone whose visa stamp is expired and they're in this situation, they could use automatic revalidation to go to Canada or Mexico and come back in to get that extended I-94 without having to file anything, without having to get the employer involved.
A lot of people are asking questions. Why can't this organization support this? Why can't that organization support it? Well, first question to you is that, what about you? Are you supporting the business immigration with no discrimination? Are you supporting the business immigration without counting the family members? Just question yourself. Don't worry about the other people who are not supposing it. Don't worry about other people who may be opposing it though. Just focus on yourself and your friends and your family members. That'll be good enough. We did achieve the 280,000 green cards, didn't we?
Monica wants to know if the I-539 is filed for an extension of stay, can we stay after the I-94 expiration date if the application is still in process and a decision is not made by then? Yes. So for example, let's say your H-4 status is expiring on September 30th and you have filed an I-539 application to extend your H-4 status beyond September 30th, but it's still pending. On October 1st, you will be considered in what's called a period of authorized stay, which is lawful presence. That means you can legally remain in the US while that I-539 application is pending, even though your I-94 has expired. Be aware that that is not the same thing as being in status. So the application, the I-539 application, doesn't automatically extend your H-4 status beyond September 30th, but it does allow you to remain lawfully. You're in a period of authorized stay, also referred to as lawful presence. And then once that I-539 is approved, it puts you back in H-4 status as if you were in H-4 the entire time.
Rami Kiran has his EB-1485 is currently in the field office. Can I expect an approval in October? I-140 is already approved. Yeah, you can expect. There is a good chance that they may call you for the interview since it's in the field office. Since your final action dates are still current because you're in EB-1, you should be getting the green card sooner, definitely.
Sarah Vannen says, I'm eligible for Dropbox. Is it okay to go for consular visa stamping in India, or can we try this in Canada or Mexico as well? So yes, it's okay, assuming that you can actually get an appointment for the Dropbox. And also, just because it says you're eligible for the Dropbox, not everybody who's eligible for it is actually getting it. So it's as you're going through the DS-160 visa application, the system will tell you whether it will let you choose the Dropbox or not. But even if you're eligible for it and you choose it, there's no appointments available to drop off your documents and do your biometrics. And so, you know, if you can get an appointment, great. But if you may be delayed, and a lot of people who are even getting the appointment and going for the Dropbox are still getting 221Gs stuck in administrative processing. So it's not necessarily safe to go for visa stamping right now. As far as going in other countries, again, if you can lawfully get to that other country and they have appointments available, yes, you can do that. That was very routine prior to COVID. People would go for stamping in Canada or Mexico, even if they're not from that country. However, since COVID, the worldwide consulates are backlogged. They don't have enough appointments available. The ones that do have appointments are generally trying to give them to their own citizens, their own residents first. So you may have difficulty just getting an appointment, even in any other consulate as well.
Question, how many times can I use an advance parole? You can use 100 times, absolutely 100 times. There are two kinds of advance parole, guys. One advance parole is the kind of card, it comes with employment authorization. Look into it, it has an advance parole. You can use it. Now, when it comes to the paper advance parole, though, sometimes the USCIS, the CBP officials would like to keep a copy of that one. Though. What I would suggest you is that when you go there, though, make some copies of it. If they want to keep it, just tell them to keep it. Because if they keep the original, then you cannot, it becomes tougher for you to travel next time. So when it's a paper copy, make sure you have a copy.
Rock Kumar says, I've been outside the US for almost 15 years and I only used 1 month. I'm assuming that's of the H-1B time. Do I still get to come back? Yes, there is no time limit on that. So whatever time you have left, which in your case sounds like 5 years and 11 months, you can get that back by having any employer file an H-1B petition on your behalf. You do not have to go through the lottery. And then they can request 3 years in this petition, and then they can also extend for another 2 years and 11 months after you're in the US.
Deepak has this question. Earlier, it was mentioned that there will be a second visa bulletin released for September. Any updates on it? Yes, we did say that. No, there is. It doesn't look like there is going to be a second visa bulletin for September because they did release that information internally. They're not giving the green cards, but for some reason they have not published it. So if somebody's priority date is still current right now, they can still file it. But our office has taken a stance that maybe that they will issue a second visa bulletin. That's the reason anything that gets labor certification approval, same day we are filing the 485 application, or at least 1 day delay is what's going on at office, because we are expecting it can happen any day. Maybe we could save this client's 485 application. That's how we are taking a stance about it though. But no, you're right. As of now, they have not issued. Looks most probably they're not going to issue a second September visa bulletin, but we can't rule it out that they will not issue it at all.
Sandeep says he has a friend who's outside the U.S. and is not getting the visa interview slot for his first time H-1B and wants to know what happens if he can't get the slot until past October 1st. The good news is nothing happens. That petition remains valid. It's valid generally for 3 years. So as long as the company doesn't withdraw it and that job offer remains available, he has 3 years to get that visa stamp and enter the U.S. So no issues with that at all.
A question that comes, can you mention how NIW's advantages over PERM? NIW, what he's referring, Bharat is referring to, is called National Interest Waiver. If you are eligible for National Interest Waiver, the main advantage is that you don't need to have any employer to file your I-140 application. That's one of the great advantage. The second thing is that you don't have to go to the PERM labor certification. The PERM labor certification takes a very time-consuming thing. You can save that. Also, another need is that, for example, if you're debating whether you're eligible for the National Interest Waiver, you seems to be marginally eligible for a National Interest Waiver and PERM, there is a third advantage. If you file a National Interest Waiver, you can extend the H-1B beyond 6 years if the I-140 is pending for more than 1 year. Okay, so let's say, for example, today you decide, oh, you want to file PERM labor certification. Maybe you're eligible for National Interest Waiver too. You can file the National Interest Waiver right now, immediately. Let's say that is September 20th. And let's say your H-1B is expiring on October 1st of 2023. On September 21st of 2023, you can apply for the H-1B extension. When it comes to the PERM, can you file a PERM in 1 day or 1 week? No, you cannot. I mean, it takes a minimum of approximately, depending on the circumstances though, the average time takes anywhere between 7 months to even 1.5 years just to file the PERM application. So you could save that time if you're marginally eligible for National Interest Waiver to extend the H-1B. You may want to consider that option too.
Gagan is on H-1B and recently came to India for a visit, realized his passport is expiring in January. His visa is valid until 2024, and he wants to know if he can use the current passport or needs to get the new passport. So you can use your current passport and enter, but when you enter, CBP will very likely cut short your stay to January 2023 based on your passport expiring. So you have to make sure to check your I-94 as soon as you enter, and then you either need to get the new passport and travel again before that expires in January 2023, or have your employer file an H-1B extension early by January 2023 so that you don't go out of status.
Can I work parallelly when the I-4 within 180 days of interfiling? Absolutely, you can with a different employer. I don't see any problem whatsoever at all.
Sri asks, when will the spillover visas actually be available in 2023? Well, technically all of the visas become available on October 1st, so they will be available October 1st, but we don't know what proportion of them will go specifically to India. As Raul was pointing out earlier, we never know until we can see how many visas the rest of the world is going to be using up and how many EB1 is using up. Only then can we determine how many will actually go to India. So that usually doesn't start happening until the third quarter of the fiscal year. Once they know kind of what the demand is, then they can start giving more to India.
Can the dependent use EAD card and AP without affecting the primary applicant H-1B status? Absolutely they can. Absolutely they can. In fact, Teja, I did. I did. When I was in adjustment of status, my wife still had a H-1B. She never used the EAD, but I started using EAD. Her H-1B was still valid until whatever period it was valid. So absolutely you can. The spillovers, there is not very many historical moments of a significant spillovers, at least not in my practice time though, except of course in 2021, you know, that 2022 and now 2023 though. Otherwise, normally spillovers are very minimal. So there's not much historical record on the spillovers, guys.
Santosh says his daughter was on H4 and filed a change of status to F1 in March, but the approval is still pending and wants to know if she can go for visa stamping in Canada based on that I-20, or is it better to go to India for stamping? I do, again, because F1 is a non-immigrant intent type of visa, she has to be able to show ties to her home country. Already difficult for people who grew up in the U.S. to do that, and then make it even more difficult to apply in a third country. So I would generally recommend applying in the home country for an F1.
Vikram has this question: what can people do where application never transferred out of Nebraska? Unfortunately, at this point of time, nothing, but we should wait for the processing time to cross. So somewhere in October or November, the processing time will be crossed. That's when the time you need to contact the service request or congressman to request a transfer. But the main thing still will be, Vikram, will be that if the priority date is not current though, what would you be requesting? We can't technically request them, hey, transfer my case out of Nebraska. What we can say is that give me my green card. They can't give you the green card if the final action date is not current. So if the date has crossed the processing time and if the final action date is current, that would be an appropriate time for you to contact the congressman to get it moved out.
Mahesh says he's an L1A, filed the green card in the EB1 category. That I-140 is approved. He submitted the medicals this week. And how long does it usually take for the green card from now? Honestly, it could be 1 to 2 years. I hate to say that, but they're not going to be processing them at the same pace that they did in the last couple of months. They still have to get through all of those October, November 2020 filings. So the online case status is showing for most people that the processing time is 23 months because the longest cases they have pending are from October, November 2020. And so the cases are going to take longer than what they have been.
One of the gentleman's case, Prasad gentleman's case, is that it says it's approved on 16th. Can I expect the green card in September? Yes, there is a good possibility that your green card probably might have been assigned before September 6th, probably assigned the number before September 6th, probably might have been approved and reflected on September 16th on the database. So yes, there is a good chance that your 485 will be, your 485 is already approved and get the green card before September 30th, which you probably already got it. I mean, it's just a matter of time that you're going to get it. Question that comes is that how can we renew the driving license when the AOS, I want your attention. How can we renew the driving license when AOS EAD extension is pending?
Good question. It's going to depend on the state, and every state is different. I know in Texas, they're not big on accepting receipt notices, even though they are proof of lawful stay for certain people where they give the automatic extension. They should also, in Texas specifically, they're supposed to accept the I-485 receipt notice itself. That is proof of lawful stay. You don't need an EAD, just your 485 receipt notice. But I know people have very difficult times getting them to actually accept that. It's different in every state, so you have to look at your state's website to see what documents that they will accept as proof of lawful presence.
I had an interaction with the Texas State Congressman, Emily, and I had a discussion with him. I explained him all the things, I wrote a letter to him. Hey, he said everything. He's an immigrant, though. He said everything. I even gave him a free consultation for some of his relative. but he still never went anywhere from further than that. It's very sad. The federal law is different, state law is different. They are, especially when we go to the main topic, Emily, we look into all these people shipping the undocumented aliens to Martha Vineyards, to the particular New York and other things, though. I want my guys to be shipped to the USCIS. Hey, you know, these guys, USCIS officials are not doing proper programming. Maybe our guys will do better programming and get these people better done. They never talk of our legal people suffering, though. Look at the press. It's all covered. Oh, they're shipping these people to undocumented aliens from one place to another place. But what about people who are legally paying the taxes and all those people? They're not even getting the driving license, guys. I don't know. I'm not a Republican, so I don't want to speak much about it, but I don't know what they're speaking about. Undocumented aliens are getting this benefit or that benefit. Look at our guys. These are legal documents. They are authorized to work for 540 days according to federal law. These damn states are not giving employment authorization. Nobody speaks about this. Nobody speaks this in the Fox News. Nobody speaks this on CNN. Nobody speaks on the CNBC. Well, you guys need to speak, guys. You need to write letters to the state congressman. This is a state subject. You need to write to the state congressman. You can also write to the federal congressman too. But that's definitely discrimination. When you are employment authorization 540 days, why can't the Texas accept it? And some states like Arizona too. Add to that.
Shilpi says, should we contact the field office for a case that recently got transferred? So be aware that you can't contact a field office. There's no contact information available there. You can't go there unless you're called in for an interview. So your only option to contact them is to contact the 1-800 customer service number of USCIS. And guess what? They're going to tell you your case is pending within normal processing time. There's nothing that we can do. So no, there's not really anything that can be done to follow up unless it's actually outside the normal processing time, which you have to go to the processing time website. You enter in the city, the field office where your case is at, to look up the actual processing time for that city. And then if it's outside, you can do a service request.
Deepak has a very interesting idea. Will USCIS reconcile all the pending duplicate applications? Can we expect spillovers more than 60K from 2023 for 2023? The duplicate applications that got approved, though, the people who filed duplicate applications that got approved, most of them, if not all of their second 485 was been denied or administratively closed because they already received the benefits, though. Obviously, Deepak, there are some cases that filed duplicate applications that are still pending. We don't know when they gave the limit of 60,000, approximately 60,000 green cards pending for Indian nationals, how many of them are duplicates? There is a chance, a good number of, I mean, not the whole number of it, but maybe 10 to 20% of them, that's my expectation, I may be wrong, maybe duplicate things that are pending there, though. Can we expect spillover more than 60K? That's going to be very surprising. I do not think so. I hope so, but when I looked into the practicality, very unlikely that we're going to have a spillover more than 60K.
Siva wants to know if while you're in the US, can I send my documents and passports with another person to India for the Dropbox to get the visa stamp? No, and actually the Foreign Affairs Manual was just updated last week to specifically prohibit that.
I'm not aware of it.
Yeah, so that was it. People were thinking it was ending third country national processing, which is not what it was doing, but it's added a line specifically saying you cannot be physically in the US and apply for a visa outside the US.
Oh, thank you for letting me know. I mean, this is a good education, guys, for immigration lawyers. Sometimes I get educated from Emily and vice versa too. In fact, most of our audiences are quite familiar with immigration than compared to a good number of immigration lawyers. That's good. It's good education for me. I thought I did not read that Foreign Affairs Manual. Thank you, Emily. Okay.
And I do have an article on that on immigrationgirl.com if you want to check that out, explaining exactly what they did change in the Foreign Affairs Manual, what the Foreign Affairs Manual even is. It governs everything to do with visa applications at the State Department.
Dilip is asking, can we file a lawsuit for the families not to be counted? Dilip, the law is not clear whether the families should be counted or not. So definitely going to the court will not help us, but contacting the administration and requesting them to change their policy would be an ideal thing for us.
Raji says, now that the dates are retrogressed, can we use the EAD or AP from the EB3 application, or should it be filed again for EB2? I'm getting this question a lot right now. And the problem is there is no guidance on what happens when you have two 485s. What happens if you use the EAD that was filed based on one? Does that mean you're stuck with that one category, or how does it impact the second 485? No one knows. So I would definitely recommend discussing it, your specific situation with an attorney, to understand the pros and cons of doing that. What are the risks involved, to determine for yourself whether you feel comfortable relying on those, or would you rather file new ones based on the new 485?
Srikar Reddy has this question. What are the benefits of I-140 with a non-profit organization? Nothing. Non-profit and profit organization doesn't make much difference in the I-140 organization. I-140 approval, priority date, it doesn't make any difference. Shaker is asking question, is it okay to go to the Singapore US consulate for H-1B renewal for Indian national? There are some people, I've seen them going to Vietnam. I did not hear any bad news from them, because normally if there's a bad news, we get to hear very fast. But for some reason, though, this is my personal belief, they discriminate Indians there. Even if you're living in Singapore, the Singapore US consulate, for some reason, do not like Indians. I don't know why. And I can feel the same thing about the US consulate in London. I can feel the same thing with the US consulates in Middle East. These are the things that I feel that they somehow don't like Indians. I don't know why. This is my personal opinion, guys.
Manoj asks, is it okay to have a title change, no change in job duties, in between the PERM and I-140 application? So you only have to worry about material changes in the job, and a title change by itself with no other changes generally is not going to be considered a material change. I don't see any problem with that at all.
Do we renew AP? Do we renew AP renewal every 12 months? Normally, AP is given for 24 months, but if it's given for 12 months, then you have to renew it. If you combine EAD and AP together, though, they normally will give you 2 years. But of course, you should not have any gap period in EAD. That's better, because the 540-day rule of EAD will only come into if you file a EAD extension before it expires. If you file after it expires, you're in danger. When it comes to the AP extension renewal, though, there is no rule that you have to file before it expires. You can file after it expires, because the 540-day rule is not there in advance parole at this point of time.
Madav asks, is the 485 visa number issued when an RFE is sent? Definitely not. So when is a visa number allocated? It's usually the very last step when they're ready to approve it. They're not going to allocate a visa number to a case where there's something missing, because you might not respond to that RFE. Your response might result in a denial, and now they've given you that visa number. Instead, they could have given it to someone else whose case is ready to approve. So they don't allocate the visa number until the very end, when they have everything in the file, everything is approvable. Right before they hit the approve button, they allocate the visa number, hit approve.
I have my EAD approved, AP approved. And if I travel using AP, still can I continue my job in H-1B? This is a very common question. We're getting it right now. Even if you travel on advanced parole, once you come back, you can work on H-1B, you can extend on H-1B, you can extend the H-4, you can extend the H-4 EAD. You can absolutely do all these things. You can not only extend, you can change the status you can change the status from you can change the employer from one employer to another employer.
All right, well, I think we're out of time for today. Thanks so much for joining us. As usual, we will be back next Tuesday at 5 o'clock Central Time to give you the latest updates and answer your questions.